John mentioned breaking down the seminar and focusing on certain areas of the law, maybe in the future. You know, one of the areas that I'm a federal public defender, so we do a number of areas. We do, among other things, bank robberies. Up until 7 or 8 years ago, until we got Mike Smart to man our Council Bluffs office, each one of us had to drive over at least once a week to Council Bluffs to appear in that federal courthouse over there. I don't know if you've ever had that experience. It's like, it's the old post office, essentially. It still is the post office. And there's this courtroom up on the 3rd floor that you think you've walked into a Judd for the Defense episode or something, or Perry Mason episode. It's got the 1950s panel on the walls and everything else like that. And I'd tried a few cases up there. There's so much to say about that. Like, if you're practicing that courtroom, you know about that crying baby that never stops crying, that ghost of a baby, that there's some sound that never stops, and it's like this baby crying, and nobody seems to know what it is. But we would get calls, we get calls at 11 o'clock in the morning saying they're bringing a new case in at 1 o'clock and we need somebody there. So you have to drive like a bat out of hell to Council Bluffs, to initial appearance and everything. I got one day, and they just picked up a bank robbery, and at Council Bluffs, we need somebody to cover the initials. So I ran out and jumped in my car and flew to Council Bluffs and went into the post office, and riding up on the elevator with a couple of guys in jeans and old sweatshirts and stuff like that. And if you're criminal defense lawyers, you know who they are, right? They're the cops, right? The investigators. They all dress like that, like they're going to blend in and everything. So I'm riding, and I don't know anybody. It's Council Bluffs. I don't know anybody, so I'm riding up with these two guys, and I asked them, passing the elevator slow for one thing. I asked them, are you here for the bank robbery? And they gave me this look, like, who is this guy? Well, apparently they weren't. They worked for the railroad agency or something like that. So, I don't know what they thought about me. But another thing, yesterday was kind of an interesting day for me. How many of you know Frank Comedo? Anybody? I'm not talking about young Frank Comedo. I'm talking about old Frank Comedo, the dad, who's probably like in his 80s now. I saw him on the Skywalk yesterday, and the thing about me and Frank Comedo is Frank Comedo was my lawyer. Back in my bad boy crime committing days, before I went to college and law school and everything, Frank was the guy that my dad fixed me up with, that his corporate lawyer fixed me up with to represent me. And and a lot of you, I'm sure, go out in the community and talk to different groups, like schools and colleges and the Kiwanis, if they still have it, and groups like that. What's the one question they always ask you, why did you become a criminal defense lawyer? And a lot of you will have the stock answers you drag out about, everybody's entitled to a fair trial and all that stuff. Well, I have a definite answer to that question, actually, and it involves Frank Comedo. And it was actually, the reason this struck me yesterday is it was 40 years ago this year. I was sitting in Frank Comedo's office, sitting in a lawyer's office on New Year's Eve day, wondering if I was going to spend New Year's Day in jail and the next 2 years in prison. And I'm thinking to myself, wouldn't it be nice to be on that end of the desk rather than this end of the desk? So now 40 years has gone by, and now I know the answer. And just like everything else, I realize I made another mistake, because I would have been out like 2 years after that, And here I am. And of all the boneheaded things that I ever did and thought I was going to try to do in my life, this is the one that stuck, and so here I am today talking about criminal cases. The other story, I'll say one more little story down there. I wasn't planning to talk about this, and some of you may have heard this already about my life path. When I had that little problem with that might have resulted in me doing a little time. I was actually a musician back in those days, and I went to college for a year. And I dropped out of college to be a rock star. And, that was very disturbing to my parents what they wanted me to be? They wanted me to be a lawyer. I didn't want to be a lawyer. I wanted to be a rock star. So I dropped out of college after 1 year at Iowa. And it was traumatic. It was traumatic for my parents. And they would go to cocktail parties and stuff. And people would ask them, well, how's John doing? And they'd say, you know, well, he's trying to find himself. You know, they wouldn't say. So then I had this little problem 5 years later, and I, you know, pretty much that whole career path kind of came to a very sudden end. It had to, and I had to figure out what to do. So to there, you know, and basically I think part of my pen, the little trouble I got into, was I went back to college and finished my degree, and then I went to law school, and they liked that. Well, then I got out and I became a public defender. And so after that, you know, people come up to my parents and they ask them at cocktail parties, what's John doing now? And they'll say, he's a musician. So anyway, you know, there's one more too that down that line, and I always wonder, you know, and you may have heard this story too, but it's been about 25 years now. I was for about 10 years I was involved with the Des Moines Playhouse, and I was in shows for about 10 years at the Des Moines Playhouse. Usually it was like man number 3 or juror number 4, or townsperson, you know, that just enough to get me into the cast parties, and I would take these roles. And one night I was sitting in Wellman's pub with a couple of my other cast members, and they were 2 gay men, actually. They were good. This is a true story. Good friends of mine at the time. I haven't seen them for at least one of them for a couple times. And one of them was a very young man. He was probably about, well, he had to be at least 21 because we were in Wellman's drinking. The other one was an older man who was my age, which at that time was probably mid-30s and everything. And they started talking about coming out, you know, and the young man had said, you know, when I came out, my parents were so supportive, you know, we love you, you know, whatever you do, we support you. We couldn't be more proud of you than we are right now. The older man, the guy my age, was saying that when I came out, my father was basically like, I don't have a son anymore, and we never talked again, that sort of thing. And it got very quiet, you know, and all of a sudden I got this feeling like they were looking at me and I'm supposed to say something. And so I told him, I said, hey, I'm a public defender. My parents wish I was gay. You know, so anyway, what I talk about in my talks, you've heard me do it before. I read all the decisions of the U.S. Supreme Court and the Iowa Supreme Court, and put them in my book, 4A Iowa Practice, Iowa Criminal Procedure. And then I talk about some of them, and you know, every once in a while when I'm doing these talks, I actually get to where I actually talk about cases. I don't talk about all the cases in my outline. I just pick a few that I think are salient or interesting to talk about, and then you can go to the outline for the rest of them. There's a couple of cases, as always, that are new enough that they are not in the outline. One of them just within the last few weeks, State versus Jefferson, Jepson, not in the outline. Mr. Jefferson committed an offense. I think it was a sex offense. He was placed on probation, and he did 4 years of probation. He was on probation for 4 years, and he got in a little trouble, and they were thinking about revoking him. And then somebody realized, well, you can't get probation for that charge. It was like a sex second or something like. I think it was sex second. You can't get probation for that. You have to get time. And the guy had been on probation for 4 years, and so they revoked his. Well, they didn't revoke his probation. They didn't have to. They resentenced him to prison, to the 10-year prison sentence. And he had done 4 years of probation. So the question is, under the double jeopardy clause, what credit does he get for the 4 years that he did in probation? Does he get any credit at all? 3 schools of thought on that. Number one is, no, you were on probation, you didn't get any time, therefore you don't get any credit. Second school of thought is, well, you should get some credit for the time you're on probation, but not a day for a day. And I think one of the formulas was just some arbitrary figure, like 1 day for every 5 days you were on probation, you get 1 day credit for prison, or day for a day. You know, every day you're on probation, you get a day's credit on your new prison sentence. And so the court considered it, Chief Justice, and of course, it was a split decision, interpreting as a law, the constitutionality of a law. God help us. You know what the rest of that sentence is going to be. God help us if that simple-minded legislation that got through the Senate, you know, makes it all the way to our, I guess it's a governor, right? She's a governor now. You know, and we have to have a super majority of the court to rule on constitutional issues. It's because we have what's perceived to be a liberal majority on the court. We're going to pass a law restricting the power of the Supreme Court because we don't want that liberal majority to be making constitutional decisions. Well, they did in this case. Chief Justice Cady wrote the opinion and essentially held that you get a day-for-a-day credit for the time that you're on probation. Probation is punishment. That's something that you can use, actually, just that dicta. Maybe it's more than dicta in the Jefferson decision, but there's a holding that probation is punishment, or at least as dicta. And in federal court, that's a big thing, especially after that Booker decision came down. And the Supreme Court of the United States was saying probation is punishment. So if you get a sentence of probation, it's not like you're getting a slap on the wrist or you're getting off scot-free. You're getting a sentence, and for some people, and you all know this if you've been representing criminal defendants for a period of time, a lot of times probation is harder than prison time. Prison time is structured. It's actually harder to get in trouble in prison. It's very easy to get in trouble in probation, and a lot of times, there's a lot of frustration in our clients about, I wish I could just go back and just be in prison all the time. They're like, in some respects, they're like your kids, because once they're in prison, they want to get out, but once they're out, they want to go back. But the bottom line is, probation is punishment, and Justice Cady said we're not going to engage, and this is my paraphrasing him, but we're not going to engage in this arbitrary, numbers game where you get a day's credit for on your prison sentence for every day you spend on probation. Justice Cady did this on federal double jeopardy grounds. I wish he could have found a state constitutional ground. I don't know where that case is sitting right now, but if I was in the Attorney General's office, I think I'd have some interest in getting some kind of federal review of that. I don't know if they get it, but they seem to be taking a big step with the double jeopardy clause that I don't know that that's been taken before. It could have done it under the state constitution and kind of protected their ruling a little bit, but maybe that won't happen. But anybody that does what I do and does these case law updates, over and over and over again, keep stressing the importance of raising issues both under the state constitution and under the state code and under the U.S. Constitution. Do it both. Don't do one or the other, or do neither. If you just say it's a double jeopardy violation, then the Supreme Court has said, well, if you don't specify, then we'll consider it under both. But if you do specify and you just say, the federal double jeopardy clause, well then, you're bound by that, unless the court takes its own path, which our court has been doing quite a bit lately. But anyway, I don't know where that will go, if it'll go anywhere. But that's a good decision for us as it stands right now. That for any purpose that they're trying to, talking about, I guess under these circumstances where they re-sentence somebody who's given probation to a prison sentence, that person gets credit for all the time they're on probation. Another brand new case, State versus Mulatillo, Mulatillo, has to do with the defendant's interest in hiring counsel of his or her choice. Our court has been vociferous on in its holding that if you hire an attorney, you have a right to hire the attorney you want to hire. Not true if it's appointed counsel. If it's appointed counsel, you pretty much get who you get. But if you hire somebody, you have a right to choose who you hire. Now, there are some limitations to that. I mean, there are some times where the conflict's raised to such a level that the dual representation, for instance, can't be allowed to stand. But it's kind of a high bar in our state, and that's kind of what happened in the Mulatillo case. This individual, Mulatillo, was going to trial. Just before trial, it was brought to the defense counsel's attention by the prosecutor that there was a witness, an informant against the defendant who the defense counsel had previously represented. Now, that's usually a conflict. And where I am, we, in the Southern District at least, we get out pretty much immediately when we find out. We don't parse words or anything like that. If we've got that, then we usually get out. You can, to some degree, get both clients to waive the conflict, but we usually get out. Defense counsel looked at it and said, well, that informant, when I finally found out who it was, I'd only really officially represented him for a month and only met with him once. We didn't talk about the facts of the case. We didn't talk about the evidence. Essentially, I prepared an appearance form. I prepared a written arraignment. I prepared a written plea of not guilty, and did my boilerplate motion to produce that I file in every case, and that was the extent of it. And the only other contact I had with the defendant, the witness, was when he contacted me and said, I'm going to hire somebody else. Then he moved to withdraw, and that was it. And so there really wasn't never talked to him about cooperation and everything, and didn't participate in any manner or form in that. So then we get this. Do we have any prosecutors here? Okay, because I don't want to insult anybody. So then we get, and I'm not here to insult anybody. I'm sure maybe there's people watching on the computer, and you know me. You look. Everybody's created equal, but just some of them become prosecutors. But then there's this know-it-all prosecutor, and there's always one of them who, after defense counsel said, I didn't play any role in the cooperation. I didn't have any communication with the defendant other than the real routine stuff at the beginning of the representation. And this prosecutor comes in and says, well, oh yes, you did. That cooperation agreement, we had that to the defendant while you were still representing him. You were represent. You know how it is. And the defense counsel says, no, I really didn't. And so the Supreme Court took it, and the district court went for it and took this attorney off the case. Said, you can't represent this guy at trial because you represented the cooperating witness. Went up to the Supreme Court, and the first thing they said is that we give a lot of weight to the representations made by counsel. So they know the know-it-all prosecutors. They've lived in this world, and so they're going to look at it, and they're going to weigh the facts and the evidence and everything. But they do give a lot of weight to the representations made by trial counsel because they're officers of the court. And when we talk about the Russell case later on, and the attitude that some of the members of the Supreme Court have about defense attorneys, but at least in this case, we're going to give some weight to what the defense attorney said. And in that particular case, the court found that defendant's right to representation by counsel of his choice was violated, and that was error. In the cases that are in the outline, this has been a big year from my perspective, for cases involving jury selection. Two huge mistakes were made by the court back in the early 1990s, back in the dark days of the court, back in the days that I used to practice in front of the Supreme Court, where they used to bend over backwards to issue the vilest opinions they could issue, and now they're backpedaling on all of them now and trying to be a little bit more circumspect. But one of them involving that State versus Jonas, which is on page 26 of the outline, has to do with how do you, when you're able to establish that a district court, when you're choosing a jury, erroneously denied a motion to strike a juror for cause. And so you've got a choice, and you either got to use one of your peremptory strikes, or you got to go to trial with this guy. Now, traditionally, before 1992, back in the days of In re Ralph and stuff like that, where we had a court that probably defended the rights of people, back in those days, if the district court failed to grant a righteous motion to strike for cause, that was prejudicial, and you'd get a new trial for that. Well, then the dark days of the early 90s, we get State versus Neuendorf in 1993, and they come up with this, to prove prejudice, when the district court refuses to grant a motion to strike for cause, you have to prove that the resultant jury, even if you used one of your peremptory strikes to get rid of that guy, you have to prove that the resultant jury was still biased or prejudiced against your client, so that you were still prejudiced. That you needed those other strikes to get rid of other prejudiced or incompetent jurors. So you have to go, I think, juror by juror and show that there were other jurors that you would have stricken, and that you couldn't because you used up all your peremptory strikes. Well, you know, that's what they said. And the bottom line is you just can't win one of these cases. I mean, that's what they're saying. They should have just issued a one-page per curiam decision and said, you can't win these because we're not going to let you prove prejudice. That's what they should have said. They should have been, well, I'll stop there because I don't know who's watching this. But so in State versus Jonas this year or last year, the court revisits that. And they look at the various tests, you know, and essentially there's two major tests out there. One of them is the old test that we had in Iowa, which is that, you know, if a court refuses to grant a valid motion to strike for cause, well, that's prejudicial, and you know, that merits reversal. Or there's the I was going to say the Nuremberg, the Neuendorf test, which essentially is that you have to actually prove prejudice by looking at the resultant jury and prove that, you know, you weren't able to strike all the bad jurors. The court looked at the Texas test in this. In Texas they have a different test, you know, and what they do in Texas is the way they go about it is if you make a motion to strike a juror and for cause and the court denies it, then what you need to do is you have to move for another strike. You have to make that motion. You say, okay, well then I move for another strike because I have to use one of my peremptory strikes to get rid of this bad juror. And that's the rule in Texas. And that's the rule that the court adopted in the Jonas case, essentially, is because then you don't have to look juror by juror by juror by juror and prove that the whole jury was biased. All you have to prove is that, you know, I lost a peremptory strike trying to strike this bad juror, and I moved for another peremptory strike, and the court didn't grant it. And and so really the focus goes back on the bad juror rather than on the bad jury. And we'll see how that plays out, but that seems to be a step back in the right direction. Yes. Why?
Just as far as clarifying that case law is just a procedural rule.
Well, you know, they didn't do a procedural rule when they did the Neuendorf test. So I don't know. You know, the court will do whatever it wants with the procedural rules, but you know, they could, yeah, they could. But you know, it's, you know, this whole 4-3 court that we've got going, and this Republican governor, and what could happen if we lose one of our justices and everything. You know, we take what we get right now and hope we can skate through the next few months at least. But the next case that has to do with jury selection, that's a big, I think even a bigger one, State versus Plain. Now that appears a number of places in the outline, and but the one big one, the one big issue has to do with jury selection, I think. And again, that goes back to a case back in 1992. State versus Jones was the case back in 1992. And it has to do with where you're trying to prove systematic exclusion of some demographic group from the jury to prove that you had a biased jury or jury essentially that was not a jury of your peers. And of course that doesn't apply just to, you know, if you're African American, you don't get a representation of African Americans on the jury. Everybody can make a claim, that kind of a claim. But the question is, how much of a disparity do you have to prove before you're actually proving that the minority representation on the panel was unreasonable? And that's one of the elements of proving systematic exclusion. State versus Plain, at least this part of it's on page 9 of the outline. State versus Jones, the court adopted considered various tests for determining prejudice, and essentially selected the weakest one. And I say the weakest one. That's charitable to the court. Actually, what they did is they selected the worst one. And basically what they did is you look at the absolute disparity test is you look at the percentage of the particular demographic group in the community, and then you look at the percentage of that demographic group on the panel, and then you subtract the percentage on the panel from the percentage in the community. So, for example, if the African American population in your district is 9%, then that's the percentage in the community. If the percentage on the pool is 8%, well, let's say 1%. Let's say it's 1%. The absolute disparity is 8% because you subtract the 1% on the jury panel from the 9% in the community, and the absolute disparity is 8%. Now, that's one thing. The other thing is that in that case, in cases that followed, they essentially said that the disparity has to be statistically significant. And we don't know exactly what the level of statistically significant is, but it's something higher than 10%. So the bottom line is they could have issued a decision in the Jones case back in 1992, just like they could have done in the Neuendorf case in 1993, and just saved the analysis and said, forget it. There's no way you're going to be able to prove prejudice because there's no way you can ever get a statistically significant absolute disparity. It's just impossible. In the state of Iowa, there's no demographic minority group that has more than 10%. So even if there's complete exclusion, you can't get a statistically significant disparity. And so for the last 25 years, we've been in a situation where you just couldn't prove underrepresentation by a minority, and the court has let that slide. So then we got the Plain case, and there's a lot of good issues in the Plain case that have to do with various issues, including implicit bias and things like that. I would say that, especially if you have minority clients, you should read the Plain case. I think it was Gary Dickey that argued that one in the court, but a lot of good stuff out of that. But the biggest one is they set aside this Jones decision, this bad Jones decision from 1992. So they looked at other possible tests. The other test back in 1993 when they were considering Jones was the comparative disparity test, which is, I think, what the defense bar was advocating back then. You go another step. You do the absolute disparity, the 9% minus the 1%, then you divide it by the percentage of the demographic group in the community. So 9% is the percentage in the community minus the 1%, which is the percentage on the jury, which gives you an absolute disparity of 8%. Then you divide that by the 9% that's the absolute disparity again, or the percentage in the community again, and you get a disparity then of like 90%. That's measurable, and that's good. That really, is something that's better quantifiable. That doesn't sound good, but that's what I mean to say. And there's the third test too, the standard deviation test. And when I read the Plain decision, I know what they're talking about, but I can't articulate it here, and I'm not going to. But you look at standard deviations and everything. That's important because the comparative disparity test is really kind of the way you want to go, except when you're talking about people from Polynesia, for example. There may be 0.5% in the community and 0% on the jury panel, and so you could prove 100% comparative disparity. Well, that's not really. You're not going to ever get a jury with another Polynesian. So you really can't rely fully on the comparative disparity test. The holding in the Plain case essentially is that we're going to use a combination of all three. We will look at the absolute disparity test. We will look at the comparative disparity test. And actually, the absolute disparity test figures into the comparative disparity test. But ultimately, we also look at standard deviations as well, because that protects the system from, absurd results, I guess. And that's the holding in Plain. So the bottom line is, at least it's possible now, at least it's possible to show that you were deprived of a reasonable, fair minority representation on your jury panel. And that's a major step forward. The next case is the Pentagon case. That is another one that appears. I think Grant Gangstead represented Mr. Pentagon in front of the Supreme Court. That appears several places in the outline. I think it starts on page 5. A lot of really good law that comes out of Pentagon. I will have to say that involves some guy that was boating out on the lake, that was drunk boating. He was drunk and he was boating. And it was like the slip opinion was like 80, 90 pages long. And it came out at the end of the term. And I have to be honest and say that, you know, on the social media, these young lawyers, and I say they're young lawyers now, they're probably, you know, the older respected lawyers now, but they're all 20 years younger than I am. But they're all congratulating themselves profusely on the social media for winning this Pentagon case and everything. And I'm reading I'm reading all these Facebook posts and I'm thinking, you know, it's a drunk boating case. And I've got a lot of cases I'm going to read before I spend my time reading a 90-page drunk boating case. But having said that, then I read it. And there's a lot of good stuff in there, and to a great degree does not apply to just boating. It applies to OWI cases as well. I've learned in the portion of the year that's followed that the district courts have not extended it to drunk driving cases completely. I know there's limitations, especially in one of the holdings, but the major holdings, the overriding holdings, I think, should apply equally to OWI cases. The one that I think should apply, I don't see any reason why it wouldn't, has to do with searches incident to arrest and the automobile searches, where they can do those in lieu of getting a warrant. You know, you pull somebody over in a boat who's drinking, and the officer says, well, you know, there's no time. We're going to lose our evidence if we apply for a warrant. And so we can use the search incident to arrest exception to do the implied consent, to do the breath test, and rather than get a warrant for the breath test, the body specimen test, I guess, really more blood tests or anything, whatever. You know, and historically, we really didn't have the technology to get a warrant if you're out in a boat in the middle of wherever they have lakes in Iowa, and you suspect the guy is drunk boating. You don't really have the time to, go drive to the county seat, find a judge, get a warrant, come back and do the specimen test. But technology has improved, as we all know. You know, they've got those computers in the police cars. I'm sure they probably have them on. I don't know if Iowa has a Coast Guard. I don't know, who stops the drunk boaters, but I don't know if they have those computers on the boats that the cops use. But they can draft the warrant right there and call the magistrate on the phone. They can get the warrant, and in a lot of cases they can do that before there's any loss of evidence and any fear that the alcohol is going to dissipate or whatever happens in time. And so historically, they've allowed the searches incident to arrest for the stops like this. But what Pentagon says is that that's not necessarily true, and it's case by case basis. But if they're able to get a warrant, then they should do that in lieu of using an exception to the warrant. And as I say, I think that one applies equally to there's no reason why it wouldn't apply equally to OWI cases. One thing that struck me was that just weeks before that, maybe days before that, the court came down with State versus Storm on page 5 of the outline, and they essentially said that, well, technology has not risen to the extent where we can rely on technology to get a warrant in time to test somebody that's pulled over for an OWI. And then they come down with this Pentagon case. Obviously, it's facially distinguishable or factually distinguishable because it involves a boat, but I don't really know what the distinction is under these circumstances. I think a law enforcement officer could demonstrate that they could not get a warrant in the time necessary to preserve the evidence, but if they can, then they have to get a warrant. The other holding, one of the other holdings that came out of Pentagon, but the other one that was probably most helpful to us, has to do with implied consent. And when you submit to a test under the implied consent law, you give a test and they can use it to, if you at least a refusal, they can use it for suspension of your driving privileges. Is it admissible in a prosecution for drunk driving, or in this case, drunk boating? If it's taken under implied consent, or is the implied consent procedure, is it inherently coercive? And to the extent that it's really not a voluntary relinquishment of your Fourth Amendment rights to agree to give a body specimen test under the implied consent law. And in the Pentagon case, the holding was that the way it went down there and the way that the implied consent law is written in voting cases, that it is coercive, because the applied to the and again, I don't do drunk voting cases, but the provisions of the drunk voting implied consent procedures are different from really what is required to get is what the situation would be if they were just looking at the drunk voting case and not the administrative case. It's confusing, but the bottom line is it is distinguishable from drunk driving cases, and the court even says that in the ruling, that the OWI implied consent rules are different from the drunk voting implied consent rules. And so that particular holding does not necessarily apply to drunk driving. But the overall holding, which is essentially that using the implied consent procedures can be, under the totality of circumstances, can be coercive to the extent that the agreement to submit to a specimen test was involuntary. I think that would apply both ways. I didn't explain it too well here, but the bottom line is that you can make the argument, I think, in an OWI case, that somebody consents to a body specimen under the implied consent rule. That's not necessarily a waiver of your Fourth Amendment rights. It may be coercive, and you have to look at the totality of circumstances to establish that it is or isn't. And I better be more clear about that. I'm going to do this in front of the judges in 2 months, and I better be more clear about it when I address it to them, because some of them have actually considered these things, and some of them have actually rejected the Pentagon analysis and OWI cases because on its face, in the language of Pentagon, it only applies, the actual holding only applies to drunk voting cases. And again, it is reasonable to say that because the statute's different. But the constitutional, as I say, the constitutional aspect of it still, I think, could apply, and it's something that you might want to be raising in the future. And just forget everything I just said when you think about doing that. Just, make the argument. State versus Russell on page 21 of the outline. Guess John Sandy actually had a hand in that. I kind of knew this was coming. I talked to several attorneys that have been using, myself actually back in my state court days, maybe all of us, using subpoenas ducus tecum to get files and records and everything prior to trial, or to get evidence prior to trial, and doing it ex parte. And the rules 213.2 and 215.2 don't really explicitly give you the right to go to a judge ex parte and get a subpoena ducus tecum to get materials provided to you in a procedure that's not a trial or a deposition or whatever, just for you to use them as a discovery tool. And some of the prosecutors started complaining about that because, damn it, what do they get? Oh, wait, they get those county attorney subpoenas where they're able to do the exact same thing, which we don't get, but they get them. And, but that is in the rules. I mean, they do get that. And the rules, the subpoena ducus tecum rules, do not really give us the right to pretrial discovery using subpoenas ducus tecum ex parte. And some prosecutors have complained, and there were a few of these cases winding through the system all the way up to the court. And the Russell case was the one that got up there. And I wasn't really surprised that the court ruled that you can't use the subpoenas ducus tecum for that purpose. you know, the rules really aren't written that way. I kind of knew they were going to come down. I think they actually did. In the ruling, there is some dicta that says that if you could show extraordinary circumstances, the court may have the power to issue them under those circumstances. As I understand, some courts have actually done that since the case came down. But I wasn't surprised by the ruling. One thing that did kind of strike me about that ruling, however, was some of the language in Justice Zager's opinion. That in the opinion, there was no dissent, there's no concurring opinion, nothing from any of the other judges saying we have a problem with this dicta. But the dicta says the reason that we're holding that it's okay for the prosecutor to be able to do this with the county attorney subpoena, and the defense lawyers don't get to do it using subpoenas ducas tecum. Well, it's because the state has an interest in managing the progression of the case, in preventing the lengthening of the trial when able, and in preventing undue witness pressure or harassment. The injury to the state is also concrete rather than hypothetical. The state has the burden of bringing Russell to trial, and as such has an interest in the documents produced. Oh, okay, well that explains it. That explains it. Okay, so it's the prosecution and not the guy in the black robe sitting up front. It's the prosecution that manages the progression of the case. It's up to them. And it's the prosecution that prevents the lengthening of the trial. Oh, of course, you know, and you've been through jury trials before, you know how it goes. The prosecution puts on like a half-hour evidence, then the defense attorney lengthens the trial with days and days and days of testimony. That's the way it goes, isn't it? Right? Right? I mean, we lengthen the trial, right? Not the prosecutors that call, you know, 6 police officers to say the same thing. It's the prosecutors who prevent undue witness pressure and harassment. Oh, that's right. We're the ones that go to our clients' wives, well, not their wives, but their baby mamas and everybody else, and we're the ones that tell them, you're going to lose your baby if you don't cooperate. We're the ones that harass the witnesses, right? You know, well, that's written right here in this opinion, so now we know it's true. You know, our concern, according to this opinion, is with the injury to the state. The poor state, you know, because the state has the burden of bringing the defendant to trial. When all the defense has to do is sit there and worry about this guy sitting next to you that may be going to prison for 10 years or 25 years or maybe the rest of his damn life. You know, for the poor state having that burden that they have. Do we have any prosecutors here? You know, it makes me sad. It makes me wish, you know, I would have taken the high road and become a prosecutor, you know, because so I'd have to get up every morning and go to my investigating officers and say, hand me the file so I can prosecute this case, rather than going out and having to work for a living, you know. Anyway, but that's the attitude that we get from our court. And every once in a while you hear them say something like, oh, the defense bar, we love the defense bar, you know, because they could have made so much more money in private practice, or all the things they say to patronize us and everything. But every once in a while the truth slips out. And this is what they really think about us, you know. You know, we're protecting those poor prosecutors that are, you know, doing everything they can to protect the system, protect witnesses, and to avoid the unnecessary lengthening of trial. So that's what I have to say about Russell. Couple of cases this year coming out of the Iowa Supreme Court that have to do with immigration-related offenses, interesting cases. One of them is, I think, was, for me at least, was really interesting. The Martinez case on page 1 of the outline. It has to do with the supremacy clause of the U.S. Constitution, kind of reaffirming what the U.S. Supreme Court had said in Arizona versus United States. But you know, there's this big, you know, we talk about sanctuary cities, and what more can our local law enforcement be doing to rid our country of anybody that speaks with an accent, or maybe doesn't speak our language at all, or whatever, comes from a different culture. You know, we don't want that. And what can we do to purify, you know, our population? And we, you know, and essentially, you know, the federal government has they've been doing that. Those of us who practice in federal court, you know, every day they bring in some young men who have wives and kids and stuff to live here. They were painting houses or something, but they'd been deported before, so they're going back again. And the federal law is all about kicking people out of the United States. The question is, what if the state wants to do that? You know, and under the supremacy clause, can they? can the state jump in, and can they get involved in the business of essentially purifying the United States of America? And in the Martinez case, the court talked about the preemption doctrine, and that's really the enforcement mechanism of the supremacy clause. When does the federal law preempt the state law? And there's two kinds of preemption. One of them is field preemption. That means that in certain areas of the law, the federal courts, the federal government, federal legislature, the Congress and everything, basically they control all the aspects of it. And they don't want the state to become involved because they want us to basically us being the feds, they want us to be deciding how we're going to punish people, who we're going to punish, when we're going to punish them, and all that. And conflict, the other kind of preemption is conflict preemption, and that looks really more of on a case-by-case basis. And essentially it looks at when a state remedy provides more or less protection than a federal remedy. It kind of interferes with state policies, you know, and it violates the supremacy clause because there's this conflict. Now, both of them are present in Martinez. Martinez involved two sections of the Iowa Code. One of them is section 715A2 2A4, which is the forgery provision that applies exclusively actually to aliens, which made it a forgery to make, etc., a writing purporting to be some kind of an immigration document, something, a work permit or something like that, that immigrants get to be able to stay in the United States. Anything that authorizes your stay here, anything that authorizes employment. If you forge one of those, and that includes carrying one that doesn't apply to you, well, that's a violation of the Iowa Code. That one is facially invalid because all it has to do with is aliens. All it has to do with is punishing immigrants. And the immigration law is one area that in the Arizona case, the United States Supreme Court indicated that there is field preemption. The United States Supreme Court, the United States government operates exclusively in that area, and states really do not pass laws and cannot pass laws that have to do with immigration. And if it does, then that's a violation of the supremacy clause. The other one was the identity theft provision of Iowa Code section 715A82, which made it illegal obtaining any benefit using false identification. And that's something that we can do. You know, most of us are citizens. Most of us are not immigrants, you know, and we can commit identity fraud. You know, I can borrow, you know, your passport or your driver's license, Richard, to get into a bar so I can prove I'm 21 or older. Although nobody's asked me for a while, but I could do that, or to obtain some benefit. But also, you can apply that also to aliens. You can apply that to immigrants, and to use somebody else's ID to prove for whatever reason that you're a citizen or whatever. And if you use, in that particular statute, that's invalid only as applied to immigrants. It's not facially invalid because it could apply to any of us. But if it's used to, if you use documents to establish legal status in the United States, then it's a violation of the supremacy clause. Interesting cases. The other one that may have more of an impact on us is Morales-Diaz versus State, and that's it's an interpretation of Padilla versus Kentucky. Morales appears on page 7 of the outline. Padilla versus Kentucky places on the defense counsel the burden of advising a defendant who's removable or deportable that there are immigration consequences to whatever happens. If they're going to plead, if they're going to go to trial, one of our duties essentially is to advise them that they're going to be deported or they might be removed or whatever. And that's been the case for the last 8 years. And in my line of work, it's a very easy task because in federal court, you know, if you're in federal court and you're an immigrant, you're going to get deported. I mean, if you pick up whatever we represent people on, for the most part, you know, if you're convicted of this, you're going to get deported. So you just, you know, are you a citizen? No, well, you're going to get deported. That's all we have to do. But in Morales involves, you know, people that practice in state court, not necessarily the case across the board. And you know, like most of the people we get, at least in the Southern District, have been deported already. So that's always an easy call, because if you've been deported already, you're going to get deported. You know, if you haven't, if you've got permanent residence status or something like that, you might stay. You know, you might have some benefits. What the Morales case says is that you, as defense counsel under Padilla, you have a duty to advise your client of all the immigration consequences. You have to talk to them about the potential for removal. You have to talk to them about the effect that a conviction under whatever they're charged with might have on their citizenship prospects. You have to talk to them about the possibility of detention, which I think just got easier in the last couple of weeks, at least easier to advise your clients about. Because your defenses against detention have somewhat diminished, I think, under the recent Supreme Court decision. You need to explain to them that if they were subject to removal, they also potentially could avail themselves of cancellation of removal. And also, the adverse of that, you have to advise them of their ineligibility for cancellation if that's the case. The practical meaning of this is a defense counsel in Iowa, essentially, you have to know immigration law. You have to know all the consequences. If you've got somebody that you suspect is not a citizen, and you know, I think it applies to permanent residence to some degree, you have to, if you don't know, you have to educate yourself. You have to bring somebody on board that's an immigration lawyer, and you have to give them, you have to impart that information to your client. I think it's a little more expansive than Padilla. Maybe not. I mean, Padilla, Padilla may mean that, but has not been enforced to that degree in federal court. But once again, the Iowa court has taken a very expansive view under the Due Process Clause, and also under the Eighth Amendment, under the Sixth Amendment right to effective assistance of counsel. And Justice Cady followed the federal interpretation of federal law. Once again, it would be kind of nice if he would have found some state basis for it, if he wanted that to survive. But as far as I know, it still survives. But you know, I don't know if it'll continue to go that direction in other jurisdictions. But the bottom line of that case is you've got to know, if you're going to represent anybody that's deportable, removable, or anybody that does not have citizenship, you better know all the immigration consequences. 5 minutes. How many of you have? How many of you have iPhone watches? Those Apple watches. My wife gave me one of these. You can't just look at the thing, you know, casually. And oh, I've got 5 minutes left. You got, you know, until it comes up. Might as well just pull the cell phone out. But State versus Williams on page 23 of the outline. Huge step backwards on speedy trial cases. Iowa has been very religious, actually, in enforcing their speedy trial rule. You know, if you're not brought to trial within the speedy trial period, if you're not indicted within the speedy indictment provision, it's just dismissal. It's dismissal with prejudice. You know, we don't see that in federal court. I don't know how many other jurisdictions are as religious about enforcing their speedy trial laws as Iowa is. But Iowa did take a step back in enforcing its speedy indictment rule under Rule 233-2D, which requires indictment within 45 days of arrest. Now, they still enforce it, but the question always is, what is an arrest that triggers that 45-day period? Now, that's gone back and forth over the years. For a long period of time, it was statutory arrest. But in State versus Wing in 2010, the Iowa Supreme Court held that arrest meant arrest in a constitutional sense. If you're in a position where you feel like you're not entitled to leave, that that the police are exercising their coercive, powers, if they're wearing the uniforms, carrying their gun, you can't leave. They bring you down to the police station, whatever. If there's an indicia of arrest to the extent that a reasonable person would believe they're under arrest, well, that triggers the 45-day speedy indictment rule. Well, in the Williams case, it just went court turned it completely around. Chief Justice Cady, essentially the swing vote, wrote the opinion in that case, and essentially held that wing is wrong, that that the drafters of Rule 233(2)D must have meant arrest in the statutory sense, which is arrest occurs when the complaint's filed and you appear in front of the magistrate. So it's easier to interpret, and there's nothing that we want more in our system than rules that are easy interpretable by prosecutors. You know, there's less pressure on them, but it's less protection for us. But we don't have to go through now an analysis of when our client was truly arrested, because we know we can just look at the docket and, yeah, the complaint was filed and he was brought in front of a magistrate on February 22nd. So the 95 days began, or the 45 days began running at that point. Interesting discussion in there about stare decisis in that decision. Justice Cady, Chief Justice Cady, realizes he's overruling state precedent, at which we do respect precedent, but we, when precedent is wrong, then we're free to overrule it. Justice Wiggins, on the other, do we have any Supreme Court clerks, people that clerk for the Supreme Court here? You know, that's one thing that gets me, yeah, that's one thing that gets me in a lot of trouble sometimes. Things get back. But Justice Wiggins took a different view, which essentially is we changed the rule here because the makeup of the court changed. We had more votes going the other way than they did in wing, and it's not fair that the law should change because the makeup of the court changes. And I have to say, he's right. He's right, but and Justice Wiggins is on our side of the court vote-wise, but they've overruled some decisions, and they've been able to do it because we have different justices from the justices we had back then. So anyway, that's the case. The last thing I want to talk about because I'm out of time is Nelson versus Colorado, a case where the defendant was acquitted, whether or not all the fees, I'm not sure if he's acquitted or if his case was reversed, but he had paid some he must have been a reversal of his conviction because he had paid fines and restitution and everything, and he was acquitted. So what do they do with all that money that he's paid out? And the court held that if that's equivalent to an acquittal, so he's guilty, he's not guilty, essentially under operation of the law. So all that stuff should come back to him. He's guilty until he's innocent until he's proven guilty. And so everything that he's paid out should come back to him. The reason I bring this up, and it's really the last thing I'll mention, is under Nelson versus Colorado, my understanding is that attorney's fees, and we don't have this in federal court, but in state court, defendant has to pay his attorney fees back as part of the court costs and everything. And I think it's still the case that if you're found not guilty, you still have to pay your attorney's fees. Is that right? I've heard both. And but I think that's still the case, that they have to pay their attorney's fees. The judge may be able to waive that, but the rationale, I understand the rationale is that if I went out and hired a lawyer, I'd still have to pay him if I was acquitted. Of course, that's when essentially, at least in the minds of the defendant, that's when you get your money's worth, is when you got acquitted. So why shouldn't I have to pay back my public defender? But I'm not sure that if that happens, if that's still happening, if it happens in one of your cases, you might want to bring up the Nelson cases, because I think there may be a procedural due process claim that you can file under the Nelson case. So I'm out of time, but I want to thank you for listening to me, at least try to get through that Pentagon thing. I should have just left it, or found some shorthand way of discussing it, because, but anyway, that's that.